So today we're going to talk about taking a deposition in a family law case. What a deposition is, it's basically a out of court meeting where there's testimony taken on the record, but it's not in the presence of a judge or, it's not in a hearing in open court. It's usually at an attorney's office or it's done virtually over Zoom, where there's an attorney who is asking either, usually it's in a divorce case, it's the other spouse, the opposing party. They're asking them questions, or they're asking a anticipated witness questions, or, whether that's a fact witness or somebody who's going to testify about something they saw, or an expert witness, somebody who is testifying as to the value of real estate or value of a business, things like that. So it's an opportunity to ask them questions and gather information in advance of trial. So the purpose of a deposition is to, again, gather information in advance of trial. That's really what you're doing for a couple of reasons. A, so that you can have a full understanding of the case. You want to have a full understanding of all the assets in a divorce case. You want to understand all the aspects of the family finances. You also want to avoid surprises. In a divorce, for example, the cause of the breakdown of the marriage is relevant. So, if at trial, the wife's going to say, oh, my husband's been beating the crap out of me for the last 20 years. You want to know that in advance. You don't want that to come across at trial and then you don't really know how to deal with it. You may want to present witnesses to rebut something that, that proves that abuse didn't happen. You want to avoid surprises at trial, and that's why you want to have a deposition. You also might want to kind of use it against the opposing party. If you think they're going to lie about something, you may want to take their deposition. If you think they're going to hide assets, for example, you want to take their deposition in advance to, you might have something in your back pocket, a hidden bank account that you know about. And you may take the opposing party's deposition and say, oh, take me through all of your bank accounts. Do you have a bank account at Bank of America? Do you have a bank account at Schwab? Go through all of those bank accounts, and they may leave out, the bank account that they're hiding. So you can gather that information to impeach the witness down the road. If you have a trial, at that point, you may want to present, you're going to present the hidden bank account, and you can cite back to the deposition testimony when the opposing party lied and said they didn't have that account. They omitted that. So those are kind of what the purposes of a deposition are. And for the purposes of this video, we're kind of going to focus on taking the deposition of the opposing party. But again, you're sometimes going to want to take the depositions of witnesses, various types of witnesses. So I'm going to kind of take you through a real basic deposition outline. So let's share the screen, share my screen. So logistically, how the deposition works, it's the two lawyers, assuming there's two lawyers. Sometimes there could be a self-represented party. And then there's going to be the actual parties themselves, or the person who's being deposed. So if I'm taking husband's deposition, my client can be in the deposition. So the wife can be in the deposition if they choose to. They don't have to be. But obviously, the person whose deposition is being taken, they have to be there because they have to answer the questions. And then there's a stenographer, who's the person who is recording everything that happens. They're taking a transcript of the testimony. So some kind of preliminary things, the court or the stenographer is going to swear in the witness, put the person whose deposition is being taken under oath. And then usually the lawyers are going to want to agree to what are called the usual stipulations. And, pretty much every deposition, you agree to the usual stipulations. And let's go through what those usual stipulations are. The first one is that objections except those as to form are reserved for trial. So you're only objecting as to the form of the question. So if there's a compound question, or if a question is ambiguous, or it calls for speculation, or, let's say, somebody asks a follow-up question that, a lawyer asks a follow-up question that mischaracterizes testimony, from earlier on in the deposition, you're going to want to put that objection on the record. Now, you don't, all you have to say is objection as to form. You don't have to elaborate on the objection beyond that. Obviously, if the other lawyer asks you, for specifics of why you're objecting, you then, will want to provide an explanation. And then separate from objections as to form, you can always object to privileged information. So if another lawyer is asking, about conversations that your client has had with you, you can object to that. That can be objected to because that's privileged. It shouldn't be shared. But things like hearsay, you're not objecting to hearsay. You're not objecting to something being irrelevant, unless, I guess, if it got like totally outrageous and somebody was going off the reservation with tremendously irrelevant things, you kind of have to deal with it at a certain point. But generally, you're not objecting during a deposition. So that's the first of the usual stipulations. And then motions to strike are reserved for trial. So those aren't necessary during a deposition. Objections for one is an objection for all. So that's not particularly relevant during a divorce case because usually there's only, there's usually just two lawyers, there's two parties. But, if there's 6 parties to a case and one of the lawyers objects, that every lawyer doesn't have to object. One lawyer objecting preserves the objection for everybody. And then the other stipulation is that you waive arguments as to defects in the deposition notice. And then the court reporter is usually going to, so those are the usual stipulations. Then the court reporter preliminary is usually going to ask the party or the lawyer who represents the party whose deposition is being taken if they want to read and sign the transcript. So what that means is the person whose deposition is being taken has an opportunity to review the transcript and make any corrections to the testimony on what's called an errata sheet. They can kind of cite like, okay, page 4, line 5 is something is misspelled, or, the information was taken down incorrectly. They have an opportunity to read and sign the transcript. So then the actual testimony begins. So the lawyer who's taking the deposition is usually going to want to give some preliminary instructions. You're going to tell the person whose deposition is being taken, I'm about to ask you, and there's no reason to be, rarely are you going to want to be hostile during a deposition. You really want to be more friendly because you're trying to elicit information. You want to make the person comfortable so that you can gather as much information as possible. If you're hostile with somebody, they're going to be kind of closed off and are going to be less forthcoming, generally speaking, with information. There are certain situations where you do need to become more adversarial, but generally speaking, you're going to want to be, keep things as comfortable as possible. So you're just going to ask the other side, I'm about to ask you a bunch of questions. Have you ever had your deposition taken before? I just ask that whenever I ask you questions, you answer audibly, because obviously a transcript is being taken and nodding of the head or shaking of the head cannot be taken down in a transcript. Also, I'd ask that you wait for me to finish my asking the question before you answer, because it can confuse the transcript and confuse the stenographer if we don't talk one at a time. You're going to want to, if you don't understand a question, tell the person whose deposition is being taken that if you don't understand a question, just tell me, just let me know so that I can ask it in a different way or try to clarify, so that you understand the question. And if you need a break, just let me know. And then usually lawyers will say, just, if you need a break, let me know. I just ask that you answer whatever question is pending at the moment. So that's kind of the preliminary. And then you're going to get more into the substantive content of what you are going to ask. Although before you get into the substantive stuff, you'll also want to review the deposition notice, particularly if the other side failed to provide certain documents that were requested in the deposition notice. There's oftentimes a Schedule A that's attached that says, you have to bring me tax returns, bank account statements. You'll usually want to go through that deposition notice and, identify which documents they failed to provide and kind of have a record of what they still need to gather, and just talk to them and say, hey, when can you get me this? And, it's a way to follow up on them providing documents that they have failed to provide. So these are going to kind of be sample questions of what I would normally ask of another spouse during a deposition. And again, this is a general framework. Every case is different. So if there are certain relevant things, you're going to want to add those in. If there are certain aspects to a case that you think are relevant, this isn't going to cover all of them. So, if there's a business that they own, you may want to, dive deeper into the business. But this is just generally. So I'll usually ask some background question, ask their age, get an understanding of their upbringing, what their family life was like growing up, get an understanding of their educational background, just to really kind of get a feel for who somebody is. Then I'm going to want to get into asking questions about the marriage. So when did the two parties meet? How long did they date? Were they married? Had they ever been married before? Do they have any children? And generally speaking, this isn't like a script that you need to stick to throughout the deposition. This is kind of a framework, and you want it to be more conversational, and you want to be curious. Don't, based on what they say, you need to be an active listener, and based on what they say, you want to ask follow-up questions so that you can get a full understanding of who they are and a full understanding of their story and a full understanding of everything that you think is relevant to the case. So try not to stick too much to the script and have it be more conversational, where you can go down various rabbit holes of getting to understand somebody and where they're coming from. So ask how you would describe their marriage. Was it happy? Was it contentious? Did the two of you plan to have children? Tell me about your children. Obviously, custody is very relevant to many divorce cases. So you want to get an understanding of who the children are, how they're doing, describing their respective roles in raising the children, describe the relationship each of them have with the children. So you'll want the other side to describe all of these things, that you want them to describe their own relationship with the children, and you'll also want them to describe your own client's relationship with the children, because you want to know what they're going to say at trial. Again, that's one of the main purposes of taking a deposition. So if they're going to say, oh, Bobby hates my husband, you want to know that in advance. So that's why you want them to describe kind of things for both parties. And then you're going to want to get into more financial things. So you might want to understand somebody's work history, where they've worked in the past, their last job, what that position was, what their income was, why they left, what their current job is, and all of that information. Or if they're not working, what their plans are for seeking new employment. Health might be relevant in a divorce. If somebody's saying, their health prevents them from getting a job, or their health has led them to behave in a certain way. you'll want to get an understanding of somebody's health background, what their ailments are, what medications they take, doctors they're seeing, how it impacts their ability to work, etc. Any anticipated medical costs. Somebody might be making that claim that they need more financial support because they have higher medical costs. You're also going to want to get an understanding of the marital problems. So when did the two of you begin to have problems? What were the problems? Was there any infidelity, dishonesty, inappropriate spending? Obviously, if somebody is making these accusations, you need to know that in advance so you can prepare for how to deal with it, how to rebut those accusations. You want to know what each party did to contribute to the breakdown of the marriage, and how you would allocate blame, whether they think they're more responsible for the divorce. Usually people don't say that. Usually they say, it's either equally responsible or their spouse is more responsible. But you want to know all of that in advance. And then you can kind of go through the financial affidavits and get a better understanding of the total financial situation. So you might go through their income on the financial affidavit, go through their expenses to get an understanding of where they're spending money and where they're spending money. You might go through their assets, including, the history of the assets, getting an understanding of whether they had any assets prior to the marriage, whether they're premarital assets, because they might be claiming that premarital assets should not be divided 50-50, that they should keep those premarital assets. Or if you're making a claim for premarital assets, you'll want to ask them about your own client's premarital assets, just to see if they're going to deny it, to say, oh no, they didn't have that premarital asset. Because again, you want to be prepared for these things in advance of trial. You want to get an understanding of the debts, the history of any debts, get an understanding of whether they perceived any inheritance, or whether they anticipate any inheritance in the future. Granted, that probably wouldn't be all that relevant, because future inheritance is not subject to division in a divorce. But so those are that's kind of the framework for, and again, this is a basic framework. Depending on your case, you might need to get more information on, you might want to get more information on somebody's particular situation and get a better understanding. Now, as far as preparing your own client for a deposition, if they're having their deposition taken, you want to make sure you prepare them in a certain way. Just make sure you tell them that you want to keep your responses as short as possible. Don't volunteer any information that is not requested. If it's a yes or no question, answer in a yes or no. You want to keep your responses short. If you don't understand a question, don't guess. Or if you don't know the answer, don't guess, don't speculate. You're going to want to say, I don't know, or I don't understand. It's important not to guess at things, because that can be used against you in the future. So, a skilled lawyer is going to be able to impeach your credibility, even over something like seemingly meaningless. If you guess and they show that you're wrong, they can spin that as you lying at trial, that you're not being truthful, and it can hurt your credibility at trial. So it's important to prepare clients for depositions with those few tips. So those are kind of the ins and outs, the basics of how to prepare for a deposition, and how to prepare your client for a deposition.